All right, we're going to start back up again. Thanks for sticking with us. It is now my pleasure to introduce the moderator of our panel, Kevin Noonan. Kevin is an attorney at McDonnell, Boehnen, Hulbert, and Berghoff in Chicago, and he's been doing intellectual property with a specific focus or a specialization in pharmaceuticals and biotechnology for more than 20 years. He is also a recognized authority on the national scene on a number of matters, including patent reform that we talked a little bit about today, and he also is the creator and author of Patent Docs weblog, which I encourage you to check out. It's really entertaining and informative. So we're going to have a great discussion, and Kevin is going to kick things off by introducing the panel and then starting the conversation. So I'll turn things over to Kevin. Thanks.
Thanks, Laura. Thanks for inviting me. This should be fun. Why don't I have the panel starting with Bill? Just tell all of you who they are and maybe what you do, what your companies do, to give a context to what you have to say.
All right, my name is Bill Baxter, and I'm an IP counsel for GE Healthcare, the General Electric company, and I have been working at GE for 8 years now. I currently represent the MR business, and previous to that, I was supporting our X-ray business and surgery businesses, and I handle all areas of IP, patents, copyrights, trademarks, trade secrets through invention capture, making sure we get our patent filings done, dealing with enforcement of our patents once they're allowed, how we're maintaining our trade secrets, IP policy and procedures, and so a little bit of everything at GE.
My name is Matt Messenger. I'm the Executive Director of the Wisconsin Center for Education Products and Services. We're a relatively new organization, about 2 years old, and we are affiliated with, but separate from, the UW, and our charge is to take the copyrightable intellectual property created at the UW and commercialize it, and then return the excess revenue back to the UW. And as our name implies, we focus on educational materials.
My name is Dave Kettner. I'm the Vice President of Legal Affairs, serving as General Counsel and in-house patent counsel for Virent, Inc. We are a renewable fuels and chemicals company here in town. I'm responsible for all of our intellectual property matters, which means chasing down inventors, getting them to sign paperwork, getting them to disclose things, and then trying to make sure that our trade secrets don't get out the door. We currently have a patent portfolio of over 80 issued patents, about 150 plus pending applications, and this is for a company that was started 10 years ago based upon technology developed at the University of Wisconsin and licensed to us from WARF.
Stephanie Adamani. I work at WARF, and I do a variety of IP-related work, a lot of transactional work, and currently a lot of IP litigation also.
Thanks, everybody. So the first question that comes to mind, we're all sitting here talking about IP, but why? Why protect IP? What does it do for you? And I guess, Dave, I'll start with you. Why do you protect the IP at your company, at Virent?
For a number of reasons, one of which is obviously as we're looking for developing our technology, as an early stage company, we're looking for an exit event of some sort, or at least for our shareholders, including also getting product to market. And in our space, IP assets are critical for that. Especially for the refining industry and looking at technology that's been around for 100 plus years. If you can step in with a fairly sizable IP portfolio, one that has been well thought of and built up strategically, that carries a significant amount of value, especially when you're trying to deal with the likes of Royal Dutch Shell, BP, Amoco, Exxon, you name it.
So you're the David, they're the Goliaths, and it sort of levels the playing field a little bit?
I wouldn't say leveling the playing field. They have
Makes
deep
it a little
pockets.
less steep against you? All right, well, GE sounds like a big company.
Yeah.
What does GE
I'm
think
the
about
Goliath
patents?
in this,
You're the Goliath, yeah.
I got some
this
stones
panel.
over here.
So the reason we get IP is one, to maintain our competitive advantage. We have a lot of competitors, some mostly large, a lot of small competitors entering the market in like China and other areas. But patenting gives us a competitive advantage to our competitors. Also, our competitors, usually the big ones, have large patent portfolios. We generally want to have comparable size patent portfolios to enter into certain license agreements if we may want to have with those companies. So the main thing at GE is to provide a competitive advantage to us over our competitors.
Yeah, a big thing for our organization, YSEPS, it's known as, is in the history of UW, there have been a lot of grants that have been done that created materials that are maybe non-patentable, that at the end of the grant period, they just end there, it sits there, and they could be potentially great marketable products that could generate revenue for the UW and possibly for the inventor. So we protect so that we can go out in the marketplace and generate revenue that we can then return back to the UW. So it's a fundamental part of our business, going out and protecting the inventions that if they weren't out in the market would just be laying there doing nothing, but we go out and market them, and then therefore need to protect them so that they aren't copied or used in a way that they shouldn't be used.
Stephanie, I'm not being unchivalrous going to you last, but the simple answer for the university is Bayh-Dole. But I want, if you want to maybe expand on that and tell us anything else about the reasons why the university does this.
Sure. I guess from my perspective, we're getting really early stage technology a lot of the time, and it requires an investment. So if we're looking for a partner to take a really exciting and really new technology to the marketplace, they're going to have to put some investment in order to get that, in all likelihood, in order to get it ready for the market. So they're probably going to be wanting to have an exclusive position. Sometime not so much, but I think like the value and the right to exclude can really be attractive if a company's trying to attract investment dollars. So our goal is to get the IP rights and deliver them to companies in a form that they're most likely to make their way to the commercial marketplace to essentially improve lives. That's our goal with the intellectual property.
So, working with university professors, the question, a lot of that's early stage. When do you file? When do you know when to file?
It's a good question. So just from a procedural matter, we have a disclosure meeting once a month where we go through all of the disclosures that we've gotten. Some of those are not ready to file. Some of them are too early. Or we look at, they only ran these tests in a little, in one particular population. And if we had more information, we could definitely have a more robust set of claims. So we think about things like that. But really what we encourage the inventors to do is to come to us early and often, because you don't really know quite when you hit that point where it is time to get a patent on file.
Bill, I can think there might be a risk that you have Stephanie does her job and does it well and gets things patented, but then when you come to the table, what do you see in terms of the risks of filing early and filing the way that some either smaller companies or universities file?
Right. I mean, one thing you need to make sure is that you fully have developed your invention and can provide the written description requirements for the patent application to allow someone skilled in the art, like Stephanie said in her presentation, to make and use the invention. If your specification is not properly, or your invention is not properly developed, and you don't have a proper written description in your patent application, that limits the claims you can get that provide the metes and bounds of your patent application. You may not be able to protect what you really need to protect or want to protect. You can't get the broad protection that you're striving for. So it is a difficult balance to figure out when you're ready to file. So it is something that we consider at GE. We do have a similar process. We have a patent evaluation board process where the inventors are incentivized to present their invention disclosures to us. We have a monthly meeting where a group of technologists get together, the IP people and marketing people get together in a room and review all the invention disclosures and determine which ones are ready for filing, which ones we want to keep as trade secrets, which ones we want to defensively publish, or ones we don't want to do anything with. So it's a very important process at GE, and we spend a lot of time working on it.
Dave, this sounds like almost that dreaded word strategy. It sounds like that there's some overarching plan behind this. What do you think in terms of what kind of strategies have you used to protect your IP, and what do you think generally people should do in terms of strategizing for their IP?
Well, I think developing an IP strategy is the most important thing that you can do. When you're starting a company or getting involved with the company, you have to figure out how you're going to handle this behemoth monster called intellectual property. Because the risks for each company is going to be different. The interests for each company is going to be different. Just because GE wants to do something from a strategy standpoint does not necessarily mean it may work for my company. And so to me, the critical point is just sit down and figure out what is your strategy. And what makes up that strategy is really you have to have a strong understanding of your competitive space, your technology, what's the potential for your technology, what's the likelihood that someone else is going to step into that space. So for example, our company, we really developed a pioneering technology in renewable fuels and chemicals. And so part of our strategy was getting down and laying a very broad patent position immediately, and doing so to try to capture that space because we didn't want to find other companies walking into that space. And I think we've been very successful to the point of where we've defined a new area for renewable fuels and chemicals. Once we did that, then we took what's called the picket fence approach, and that's really start building up layers upon layers and upon layers of different patents claiming different aspects of our technology, and then growing it outwards from that. And I think that was critical to getting us where we're at today from an IP standpoint, and it starts with that forethought. When you start looking at foreign filings, again, understanding where's the likelihood that your technology is going to be deployed, or where goods can be purchased, or where they're going to be manufactured. And that's going to help with the thought process around what country should I be filing in. It doesn't make sense to go ahead and pursue a patent in Japan if there's no way that product's ever going to be manufactured in Japan or filed in Japan. I mean, Japan seems kind of cool to file in, but it's really expensive, and you can't read the patents anyway. So, I don't know what they're good for.
They look pretty.
They do look pretty. And then lastly is on the first to file. To really understand, is it important for me to file something today, knowing that I'm 75% of the way there, or if I give it another 3-4 months and go directly into a utility application once I have everything built out on my filing, you could be in a better position. I just had a case, it completely blew my mind that this happened, but we went ahead and filed directly as a utility application. I got the first office action 12 months after the filing, which was great because now I had a 6-month window where I could go ahead and file a CIP and include a whole bunch of new data and new information that is going to help that filing or pursuing that technology. And that's the first I've ever heard of an office action, first of all, coming out that quickly out of the patent office.
They're trying. They're trying.
Yeah, they are
now.
trying.
They are.
But it's those concepts that you have to think about, and it's more than just, hey, I have an invention, let's file a patent, because that's the thing to do.
It's funny because what I get from listening to you is a focus that I'm sure has to do with a product strategy and a commercial strategy. So just to contrast that to the university, now, Stephanie, that's not the kind of thing you're dealing with, but how do you accommodate the fact that what Dave's going to want is IP that's going to sort of promote and foster that product/commercialization strategy, which, thank God, the university really isn't doing. That's not what the university's role is.
Yeah, well, I think that when we license to startup companies, we're often working with them to develop the patents as they come forward. Usually the inventor is still working in that space on the campus, so there may be follow-on IP. We listen to the company's input if we're responding to office actions. And then, and we fully expect that companies are going to start to develop their own IP precisely for the reasons that Dave talked about, because you want to have layers. First of all, there's going to be follow-on inventions, and inventions build on another, and then you have the picket fence approach that Dave's talking about, and increased value for your company in that patent portfolio. A lot of times we're filing, some of the toughest things are we get inventions that are really way before their time. And so we had a big enforcement several years ago for an invention that wasn't ready to go to market or wasn't used by anybody for over 10 years. And we're looking at that and saying, wow, this is really amazing. What's it going to do? Who's going to use it? Is it worth putting the money into it? And sometimes we just take a flyer on that. We don't have a commercial partner to help direct it, but it's, it could be groundbreaking if that's the way that things go. So we're operating in different spaces in terms of strategy, but we have different strategy considerations.
Sure. Now, in terms of copyright, this is something that you do in the United States. Do you do it internationally? We heard Dave and Stephanie and Bill even talk about foreign filings and filing in other places of the world. How does the copyright strategy work for that?
Well, it depends on the type of product that we're working with. We do have precedent of doing some copyright protection in countries outside the U.S., but a lot of our work is within the U.S. But again, it just depends on the type of product that we're working on and kind of what the market space is, like everyone's been saying.
Okay. Has anybody in your space talked about the Kurtzsang decision? Okay, I won't go into it much. This is the Justice Breyer wrote a decision this past term that says if you copy a lot of things in Thailand and bring them over to the United States and sell them, that's not copyright infringement. So the only reason I bring it up is because it sounds like the kind of thing that could make two things: one, make your life more difficult, and also make things a lot more expensive in Thailand because things are much cheaper there only because the copyright holder usually permits them to be. We won't get off on that tangent. Stephanie talked about provisional applications and how people do that. Bill, how do provisionals work in your company? Is that something you find to be useful?
Generally, we have a policy against filing provisional applications. Again, it comes down from our corporate office. We want to have a fully developed patent application ready to file. So we have not generally been filing a lot of provisional applications. In instances where we do, it happens where one of our engineers or technologists wants to do a publication or is presenting at a trade show, then we need to get the filing on file before they do that. Or so just generally we don't, but I think we're going to revisit that with the new AIA law coming out, that we might file more provisional applications. The reason we don't is we want to be careful to have a fully developed specification in our patent application, so we're not losing any value by not including everything we can about the invention in our initial patent filing.
Yeah, I've seen provisional applications that were essentially something on a bar napkin with a cover sheet on it, or maybe not much more than that. And just to give the audience a little very brief background, provisional applications are a creature of the anomaly that occurred when we went to the 20 years from filing system, that if you filed the application in the U.S. and you filed the same application in France on the same day, the French application would get an extra year of term because its U.S. term wouldn't start until the following year when it came into the U.S. And so the Patent Office came up with this one extra year of a provisional, which gives Americans the same right, but the Patent Office does nothing with the application. It sits there. It just gives you the right to convert it in a year, which is what people do. Initially, people thought, I can just put any idea I have, a PowerPoint presentation or something in, and then there was a case that came down that basically said, what you see is what you get. And if you don't have all the other requirements of patentability, then you don't get anything. When your company looks at IP, Dave, is that something you think about provisionals, about getting an extra term? Because it may not be something that matters very much for a mechanical device. If you think about this little iPhone, I wouldn't want to have an iPhone from 1993 or a cell phone from 1993. It would be a better phone, but I probably wouldn't want it, okay? But for the kind of things you're doing for fuels or what happens in biotech and pharma, these are things that don't obsolesce quite as quickly.
No, they never obsolesce. I mean, they just kind of sit there. But no, I mean, in our industry, trade secrets and patents are king. And quite frankly, more and more in the refining space, trade secrets carry a significant amount of value. And so, the question for us is less about do I file a provisional, but do I file an application at all? Because there is significant value on the trade secrets, and when you start looking at building a production facility, that adventure alone is 5 to 7 years. So you've already gone through almost half of your patent life, or just short of half of your patent life. Just to get a product up and out the door. And then when you start looking at other facilities coming online, how many more are going to come online in the next 13 years, to the point then you're starting to wonder, well, have I just given away the store? Now, ideally, if you have both, a nice trade secret portfolio and a patent portfolio, you're going to be in a better position. Now, with respect to provisionals or utility applications, it really comes down to, do I think someone else is going to be filing something, or are we going to be talking to a potential investor or potential partner that I want to make sure I have something on file before we have that meeting?
Okay, so is there any delineation? You said time was one of them. that clearly if you don't want to file on something because your patent term would be over before you got something to market. And this is something that in pharmaceuticals you don't have as much of a problem with because you have a way of maybe recouping some of that. But any other considerations about why to keep something a trade secret versus patenting it?
Yeah, I mean, part of it, comes down to, are you going to be able to police it as a trade secret? So, for example, in our space, our technology depends on catalytic technology. So, you can imagine in oil refineries today, they use this small little piece of metal that's on top of maybe some silicone, and oil runs through it, and it magically turns it into all these different products. Our technology is not too far removed from that. It's just we're using plant biomass instead of oil. And those catalysts themselves, the secret sauce is how do you make the catalyst? So for that, I know I could go into China, Russia, all these other suspect countries, and build a refinery, make the product, my catalyst over here in the United States, and ship it over. And I'm going to have a strong IP position because they're not going to be able to duplicate that catalyst. So for me then, the trade secret question is, can I maximize the value by maintaining it as a trade secret, and am I going to be able to maintain it as a trade secret?
I hear reverse engineering under this that you're telling me, and I guess Bill, I want a question for you on that. It's if you can't undo the secret sauce,
Right.
if you can't figure out how to do it, then secret sauce, Coca-Cola formula, things of that nature. Premarin actually is another one. It's a menopausal drug that nobody knows. I mean, they know what's in it, but they don't know how it works. Impossible to reproduce and not patented. So that's not being able to reverse engineer is something that seems to be important. What's important for GE in this?
It is very important. I mean, that's what we look at when we're analyzing these invention disclosures that come in. We have a lot of trade secrets on our manufacturing processes and in our software algorithms where they're not detectable. Someone cannot reverse engineer it. In the manufacturing process, it's only done at GE facilities. Once they see the product, someone else would not have any way of ascertaining how that product was made with the process that we're doing. It's the same thing with the algorithms. Other than seeing the source code, they wouldn't be able to figure out what the software algorithm was. So we have a lot of emphasis on trade secrets, both in manufacturing processes and software, because the main reason is that it's not detectable, it's not reverse engineerable. So that's how we handle those types of inventions.
I think it's important to point out that you can extract a royalty on trade secrets into perpetuity.
Right.
But for patents, you're limited to the patent life.
Stephanie, is there any place for trade secrets in the university?
Not really. Not that I can think of. I'm sitting here thinking about
Good
this.
parking is a trade secret.
Well, the university is essentially geared towards disseminating knowledge and teaching and educating, publishing. So that stuff is really pretty much incompatible with trade secret. So occasionally it comes up, but secret isn't compatible.
Does that make working with somebody like Dave and his company a non-starter? Or you mentioned that that usually there's the initial invention and then there's later invention. Mm-hmm. Do trade secrets maybe have a place in that later invention, and then it's the company doing it, not you?
Yeah, and really we don't really want to know the trade secrets because we don't want the responsibilities that go along with maintaining trade secrets and the liabilities that can come with that. So that's usually something that would happen after we license fundamental technology and doesn't involve us. Okay, well, you said licensing. When you license technology, what typically happens in terms of the IP? Who controls the IP at that point? Who controls the filings and all of that? Yeah, so we have a policy that WARF maintains the filings, and the reason is that WARF sees itself as stewards of the technologies. We license. We hope that we have great relationships with companies and that they develop that technology for the commercial marketplace and that relationship goes for the life of the patent. Sometimes it doesn't work out that way. Companies lose interest or they're not interested. And if we had turned over the prosecution to them, likely the prosecution would reflect that company's strategy. So while we get input from the companies we work with, we try to keep, the broader purpose in mind. So we maintain control over filings. I'm not sure if that's how every university does it. I think there are variations, but it's not uncommon.
Bill, would there be a tension, a conflict of interest there? It sounds like Stephanie was saying, well, reflect, I'll go further. I mean, I could see there being an advantage to a company, especially if they developed a secret sauce, to not having patent protection, because then royalties and milestones are not owable. What's been your experience with that?
Well, like Stephanie said, the companies want to have a say in where the patent applications are being filed, and typically the agreements that the companies have to pay a certain percentage of those fees for that, I guess, option to be able to say where they want the patent applications filed. In the trade secret sense, we want to, like Stephanie said, they don't want to know about it. We want to keep everything secret. It's easier for one entity to maintain the trade secrets, so we would not have generally any collaboration between either a third party or on trade secrets. But my experience in working with the universities and other entities that we work with on patenting, if we're paying a license fee, we want to have some input on where the patents are being filed, and we can work out payment fees, a proportion. Either we pay some, or they pay all, or we pay all. It depends upon the type of agreement and company we're working with.
How about you start now, you said trade secrets you don't want to know, I understand that. What about after arising technology? Dave, how much would you work with, do you think, a university person? You get the original patent portfolio, whatever patents are filed, and now you're going to go forward to commercialize. How much opportunity is there to work with the university person who first came up with it, or is this something that you'd rather take over total control?
Well, a good lawyer answer is, it kind of depends. But there's typically an opportunity to continue to work with the researcher. A lot of it depends upon what their interests lie, because there's a lot of brilliant researchers out there, and they're brilliant because they do what they do, and they work on multiple different things, and they take ideas and they go into very interesting directions. What you have to be cautious about is making sure that the interests in the company and the researcher don't at some point conflict, because you can always run into a situation where you have a researcher who is, here's an idea, at a nice little meeting, and then, decides to run with it a little bit. Or they could diverge and go in a completely different direction, where, now there's a conflict on time, the expectations for that researcher. But I'm also very, very much familiar with companies who have long-lasting relationships with the researcher themselves, because they have an ongoing interest, and they can separate what they're trying to do in the lab versus what they're trying to do in the business. It depends on the personal nature of that relationship. Sometimes they work, and sometimes they don't.
Stephanie, do they work? Have you seen them where they work, and it's not a problem?
No, I think we have had. I think there are some really good examples of long-standing relationships. I think of the MR group, the medical imaging group with the University of Wisconsin and GE. We have great researchers there, and they're doing cutting-edge stuff and really work well with the industry. So I think there are a lot of examples of success.
Right.
So without telling tales out of school, what have been the problems? Nothing ever, when human beings are involved, nothing ever runs smoothly all the time. What kind of problems have arisen that you can think of?
Well, I think one of the problems is it goes to the conflict of interest question or issue that Dave raises. Researchers are on campus because they want to do research, and they want to be able to do what they want to do, and they want to be able to get funding and solve problems or investigate problems for whomever. So sometimes researchers are put in a situation where they're getting or potentially getting funding from various businesses that might see themselves as competitors. I think that's a place where problems can arise, particularly if one of those companies is a licensee. We don't have a lot of control. We don't have control at all, and we don't want control over what researchers do. So there's just that potential, because as I've learned, I've been with WARF 7 years, and the university is an interesting place. There's a lot of people who really direct their own, their own paths there, and that's part of what makes it great. But it can be difficult to manage when you're a business, and you have different ideas about how things should go.
I want to ask Bill that same question, but before I do, one of the things you mentioned was assignment, and the kind of an interesting way. There was a case that came down a year or two ago where a researcher working at the university went and worked at a company to learn a technique, and the requirement was to sign a piece of paper that said, if I come up with anything, you own it, company. And then went back and assigned all their patents to the university, and when the university knocked on the company's door and said, you're infringing our patents, they said, oh, no, we have this assignment from you, and in fact, the Supreme Court, yeah, that's right. How does WARF handle the assignment and ownership issue in that context, given obviously they're talking about conflict of interest and an unwitting one, because this researcher didn't appreciate what he was doing when he did it.
Yeah. It was an assignment cloaked as a visitor's agreement. If you look at the actual document, you can read it. It's about a page and a half, and buried in with the visitor's agreement is what you need to sign to get into the facility was the assignment of IP. So that's interesting. It just kind of makes you want to pay a little bit more attention to what you're signing. So WARF can't do much about it. We've just tried to work with the university to make sure, and I've said this word like 100 times tonight, but processes and procedures. So the university has changed some of the forms. So if you're a researcher and you accept funding, you sign some forms, and they've changed that to hereby assign. So I hereby assign
Magic
the
language.
IP that might result from the research. And then the university has really increased some of the services that it provides when looking at consulting agreements or other agreements that researchers are asked to sign to make sure there are not conflicting obligations. So the university has really stepped up, and we've tried to work with them on that to make sure, to try to avoid that situation really from happening.
No one's happy with that. And you did say that, the fact is that an inventor, unless he assigns his or her rights, can practice and can assign independently of the other inventors, so it can make kind of a mess. I'm wondering about conflict of interest with copyright stuff. Is there ever an instance where the person who produces whatever it is you're protecting has has whatever interest there could be, and I can't think of one, but something that would create a conflict with you because the owner is the university?
In some situations, we haven't run across that too much yet. And again, we're a new organization, so I don't have too much precedent. But we try to exist so that we can get rid of conflict of interest, and so we can both accept and help the UW's interest, but also help the inventor's interest as well. Mm-hmm. So we try to exist so we can offer some of that transactional flexibility to be able to circumvent any conflict of interest issues that might arise.
Okay. And that's working.
So far, yeah. Like for example, we work with some inventors who create products for English language learners. Mm-hmm. They give us a license for those products, and we then farm those out to different publishers or sell them directly, and then we keep the revenue back to the individual. And those individuals who invented the products have the incentive to work with us, and the UW also benefits because it helps build up YSEPs in our endowment, and that eventually goes back to the UW. So it's working in that example, and I think it can work in other ones too.
Kind of ashamed of myself. I'm a lawyer and I'm just talking about money now. But obviously one of the things that's important about IP, and we heard it from Dave, we've heard it sort of from everybody, is the investment aspect. But Bill, how does, besides your internal R&D, how does the investment in technology work, and GE's investment in technology, not just its own R&D, but other R&D from other people?
Yeah, one thing is GE funds their IP through their R&D investment, and we try to pair our INP filings based on the same amount that we have in our R&D investment. Another aspect to think about it is that we want to make sure that we have the money available. So, as Stephanie said, it's very expensive to file patent applications all over the world, so we continually look at our portfolios, look at our patents, look where we're filing, and make sure that we want to maintain those filings. If we don't, we abandon some of those patents, and that saves us some money. Another way we look at budgetizing ourselves is monetizing the patents that we do have. So we go out and look for licensing partners of our patents, try to enforce our patents to get some revenue back that we can use then to file additional patents around the world. So, the R&D investment from the corporation, And then monetization is a very big aspect of us funding our IP work at GE.
Just for the panel generally, is there any ever time in your experience when protecting IP has harmed investment or made it harder to invest in something or develop something that a company wants to develop?
I personally can't think of a situation, although I was involved in a due diligence once several years ago where part of the transaction was, you had to call down the IP assets. This particular company had, filed broadly, and the maintenance on that portfolio was just way too much. And so, the company was actually forced to, get rid of a lot of its filings. But other than that, I can't think of a situation where someone has come back and said, because you have such a IP portfolio, we're not going to invest in you.
Right. I can't think of
What if it's a bad IP portfolio? In other words, what if you're in a position, I know Bill talked about it, that you have to satisfy written description, things of that nature, and not everything is done perfectly all the time. So has been an opportunity, I can think of an opportunity, but I'm going to ask you guys if you've ever experienced one or known of one where there was something that was good, but either it was filed too early or it wasn't properly supported or that sort of thing, or just did not claim very well, because once things publish and then they become prior art, and so it's hard then maybe to do it right after somebody has disclosed it and done it wrong.
Yeah, I mean, at GE, like I said before, we continually to look at our portfolio and the patent claims and make sure that they're good claims, and if they're not good claims, then we consider dropping that. And then we have a licensing department at GE which takes the patents that are now no longer wanted by the business, and then they try to license it to other companies that out there to try to get some revenue back from those patents. But it's a continuing process at GE where we take a look at our portfolio, and some of the bad patents that we decide to drop and not pay maintenance on those.
Does that happen at the university, Stephanie? I mean, granted, people who work for the university always do a very good job, but in terms of the disconnect between what you think an invention will be at that early nascent stage, and then a company comes along and says, oh, any experiences like that?
I know we also drop filings if it's just like, okay, we took a flyer on something and we thought it might become the state of the art and it didn't, and there's no opportunities and we're just spending money maintaining something that we don't see anybody commercializing. Yeah, we would abandon it. We also sometimes get disclosures and we think about, well, is patenting going to really make this more likely to be commercialized? And if the answer is no, if it's like, well, no company's really going to want to maybe it's a better way for a researcher to make a research tool or something, and we just say, well, researchers could do this in their lab for they don't have to buy it from a company, there's no advantage to that, then it just doesn't make sense to make the investment. So we'll just say, publish the information, put it out there. People will do it then if they choose to, but it's not, patenting isn't really the best way to get the information or the technology out there.
So I just want to add one more thing. I think an effective way to manage a portfolio, there's one thing to get it, but then what do you do with it afterwards? It goes back to the concept of, what's your IP strategy? It does, kind of blows my mind from time to time when you may be talking to a particular researcher and you're saying, we're just not, I don't see any deployment anytime soon in Colombia. Let's drop that patent, and they may be hesitant to do it. But this researcher, has no problem running a $20,000 experiment. That's just not going to work just because out of idle curiosity. You've got to learn to drop some things. And, just as there's some business decisions where you just say, no, we can't do it right now. At some point, you just, even though you made the original investment and file that application, at some point, you just got to let it go.
Stephanie talked about the AAA briefly, and really the only part of it that I want to reference is the idea of first inventor to file. And Bill, is that changing the way you're approaching IP in any way?
Yeah, it is. Like I mentioned earlier, GE has this patent evaluation board process where we rate the invention disclosures to file patent applications on or to keep them as trade secrets, etc. But once we rate invention disclosure to file a patent application on, we're very diligent to make sure that the patent application filing process happens quickly. If we're doing it internally, we have about a 2-month turnaround to make sure that happens, that the patent application is filed, and we're very diligent on our outside counsels to make sure that the patent application is filed within the 2-month window. So we're very diligent to make sure that it does happen quickly once we rate an invention disclosure to file.
Dave?
I think if anything, it goes back to what I said before. It all depends upon what are the risks associated with someone filing first, and for us, there's certain areas in our technology space where absolutely we'll file a provisional because there's so much activity. But there's other areas where I know there's none. And so in that instance, I'll make sure that we have everything fully developed before we file.
Okay. Stephanie, how does the pressure to publish by the university researchers influence that sort of decision making, especially with regard to the AIA?
Yeah. Well, we met with all of our attorneys about a year ago and said, okay, we need faster filings, so we want everybody to be ready to make filings quickly if something comes up. We've kind of been in that position before anyway, because if we wanted to preserve foreign rights, we need to get something on file before the publication. And again, it's the university, so people want to publish. We get things last minute. Oh, I'm going to give a talk on this next week, and then we have to really make a decision and get a scramble and file if that's something that we want to do. So we don't have a lot of control. We try to educate inventors to let us know early if they have inventions or publications that are coming up, but and we do the best we can then to manage that. But we've definitely tried to speed up the process.
We're going to take questions in a minute, but I guess before we do, starting with Bill, any final thoughts? Anything you want to tell people? Last words.
I guess just the point that intellectual property is important to a new business starting out. Is something that's complex area. You probably need help in determining what the correct IP strategy is for your company. So I would suggest you seek advice from people that you know or attorneys. But it's an important part for starting a company.
Yeah, I'd just like to echo that. It obviously is an important part, as we've been talking about, but it's also a part of an overall startup strategy. So it's important to note, too, that obviously getting customers, moving quickly, and other typical business concepts are important, too. So while IP is core to a startup, getting customers and moving quickly is also important, too.
I guess I would just echo everything that's been said by Matt and Bill. I guess the other thing I would point out is, especially if you're starting a company, you're looking at spending a lot of money over the next number of years. And your IP position is going to be a significantly important part of that. And don't be afraid to spend the money at the very beginning of your relationship to make sure that you build an appropriate IP strategy. So what was just said is important. Talk to and consult with those people who are experts in the field. I'm not in private practice anymore, so I'm not looking for your business. But I've been on the company side for a long time, and it's critical that you take that very first step because that's going to set the platform for you for the next number of years moving forward.
Well, I think I agree with all of those statements. I think also the relationship building, if you find an attorney that is good and will listen to your questions, and if you challenge them on questions, be open to a discussion about what the right path is for your company. That's really important. Is really costly, so you want to make sure that, like Dave said, that your strategy, your investment matches your strategy. Also, there are so many resources out there now available. I think the USPTO is a great resource if you're just looking to try to learn some basics. The copyright site that I mentioned also has tons of information, so you can really get yourself educated on these topics really pretty easily with the resources available. Lastly, I think we see this with companies a lot. The IP is, it has value and it is a start, but it doesn't really do much on its own. It needs the people and the investment and the business strategy to really move it forward, and without that, it kind of languishes, and we have seen that, unfortunately. So you can be losing time on your patent life if you're not just moving your business aspects forward.
Okay, well, thank you very much for the panel, and we'll take questions.
When Stephanie was talking, a gentleman asked about public disclosure on ideas, inventions that hold future patents. In the mode of being a startup or early development company, you're a lot of times going before potential investors to raise capital. They're all very much interested in your future direction in terms of IP. So I guess I'd just ask it again in terms of the panel. Any guidelines or rules of thumb or definite lines you don't cross when you are trying to portray what future may hold in terms of intellectual property and patents, and what you should stay away from, what you can't say?
Yeah, I guess I'll just make a comment on that. It's very important to have either a confidentiality agreement in place or a non-disclosure agreement in place, and I guess I would suggest it be drafted by a competent attorney to make sure that you have covered all of the bases. Another thing to think about is, if you're having a discussion with a third party and you do have some, core ideas or inventions for the company, does it make sense to file a patent application, whether it's a provisional or utility application, get those on file before you have these communications with the third parties to make sure you're thoroughly protected. And if you can't do that, then it's important to have the non-disclosure agreement or confidentiality agreement in place.
I think what I would add to that is, first think about what you have to disclose. Because if you're talking to financial investors, you probably don't have to disclose much about the technology. In fact, they probably don't want to know much about the technology and want to know more about the opportunity from a financial standpoint. And I've sat in many, many investor meetings where as soon as they start talking technology, that's when I see smartphones come out. So, you have to think carefully what really needs to be disclosed. And I think developers of technology spend most of their time talking about why it's really cool and how great this invention is and what are the nuances with it, and lose track of the business side. And they have a tendency to want to disclose more and more about the technology than they really need to. And so what I would caution is obviously always put an NDA in place. Always put an NDA in place. If someone doesn't want to enter into an NDA, then you have to question whether or not they're sophisticated enough for you to be talking to them. And then beyond that, just think about really what needs to be said, because quite frankly, it's probably not as much in depth as you really think.
So if you decide on a trade secret, can you change it to a patent at a later date, or are you stuck with your decision?
No, you can file a patent application on your trade secret if you want to at a later date, as long as it's maintained its secrecy. It's not sneaked out in the public domain. You still can file a patent application on it.
Hi, I had a question about somebody mentioned the importance of getting as much information as possible into the spec, and then you have your first patent, and then you can develop a patent family with CIPs, continuations, divisionals. Can you maybe just give us a little more information about those subjects? Thank you.
That's you, Stephanie.
Okay. So when you get your original patent on file, it has a spec. You generally want that to be broad, and then you have your claims in there. As you go through prosecution, sometimes you get new information, so you want to add new claims. You might want to do, well, a continuation is basically you're adding new claims but using the same specification. So the more complete and thorough your specification is, the more likelihood that you have to work with the claims, whether in that application or in subsequent applications during the prosecution process. So it's nice to get a really thorough, broad specification that has lots of good support for a variety of claims at the beginning. We don't do a ton of CIPs at WARF, but maybe Dave or Bill can elaborate on that a little bit and how they see value and what the specification should look like for those types of apps.
Yeah,
Go ahead, Dave.
Thanks. To me, there's somewhat of an art around taking that approach because you want to, in your initial filing, disclose enough but not enough, so to speak, so that you can do more selective filings later. So, for example, if you're describing a very new process and you're able to describe the steps in that process fairly broadly, but not go into specifics on smaller, finer points within that process, because quite frankly, you don't know at the time that you're making that initial filing. You see it often in the pharmaceutical space, and I'm starting to see it more in our space as well. Is especially when you start looking at these catalysts I talked about earlier. Our original filing had disclosed those concepts of those catalysts, but now I'm able to step in and say, here's a catalyst formulation that works really, really well, and it works a lot better than I would have expected. And even though it may have been mentioned in my earlier filing, so that I know that no one else can really play in that area, I now have the opportunity in this selection case to really argue for that more narrow of a patent and be able to do so in its standalone application. So where the art comes in is really writing the spec in a way that discloses enough but doesn't disclose everything, but still falling within the requirements of the law. So good luck with that.
Yeah, another aspect of writing specifications is you have to keep in your mind that it is going to be published and it is going to be publicly disclosed. So that's another thing we think about at GE when we're looking at invention disclosures and whether to file patent applications, is do we want our competitors to know what we're doing? Do we want to tell them how to do this? And sometimes the answer is no, we really don't. So we don't file a patent application on it. Sometimes you want to keep stuff close to your vest to keep it away from your competitors.
And I guess I would add on top of that is strategically you can throw in a bunch of examples that you really don't care about. And, because it is a publication, you're using it for defensive purposes, it can force people to go down the wrong path. So patents are a very powerful thing if you do it right.
This question is for Stephanie. You described the agreements between WARF and the businesses, and you mentioned that WARF does the licensing. So I was just wondering, what do the agreements between the inventors and WARF tend to look like?
Oh, sure. So we have a pretty standard agreement that when inventors disclose to us and we decide that we want to accept that IP, so accept title rights to the invention, and go ahead and file on it, we do a standard memorandum agreement with the inventor. And they basically, so a couple of things. If there are funding strings, the inventor is obligated to assign to us should we elect to take it. If there's not, a lot of inventors still elect to assign to us because they don't want to bother with patenting and licensing. So in the memorandum agreement, inventors get a percentage of the revenue that we may generate off of that invention through licensing, and then they also agree to help us as needed with the prosecution or enforcement, and typically they meet with the attorneys and we kind of work on the drafting and that sort of thing. So it's a pretty simple, it's just over a page agreement. but it is an assignment agreement, and then it has the consideration of the fact that the inventors get a revenue share for revenue derived from the licensing of that invention.
Okay, if there's nothing else, I'd like to thank the panel, and then we'll meet at the reception.